Good morning, everyone. Welcome to the Power of Song, Repercussions for Freedom of Expression and Digital Rights in Hong Kong. We're delighted to have you with us today. This event is organized by Global Freedom of Expression at Columbia University in partnership with Article 19 and the Georgetown Center for Asian Law. We're also grateful to the Internet Society New York chapter for supporting this live stream. Today, we are joined by an esteemed panel of legal scholars and activists, all dedicated to discussing the growing restrictions on freedom of expression in Hong Kong. According to Article 19's Global Expression Report, Hong Kong has seen one of the most drastic declines in press freedom over the last decade. This downward trend escalated after the 2019 democracy protests, following which the Chinese government introduced a national security law. The law's sweeping provisions have severely curtailed peaceful expression and silenced criticism of government actions, all the while expanding police powers and compromising independence of Hong Kong's judiciary. Since 2020, thousands have been arrested under these new restrictions. 20 online media outlets have been forced to close, and various websites have been blocked. In just the last 6 months, at least 10 court rulings were handed down in cases related to alleged acts of sedition. These include prison sentences for activities such as wearing T-shirts with political slogans, writing democracy messages on bus seats or posting them on social media, and even journalists being prosecuted for their work. One of the most striking cases, and the main focus of today's discussion, is a legal battle over the song Glory to Hong Kong. This song became a powerful anthem during the 2019 protests, and to the great dismay of the Chinese government, has been falsely presented as Hong Kong's national anthem nearly 900 times, even during international sporting events. Online, the song's videos garnered millions of views and likes. In June of 2023, the Hong Kong Secretary of Justice sought an injunction to ban the song's circulation. But while the initial court ruled against the injunction, stating that it would infringe on individual rights, the appellate court later reversed that decision. This reversal demonstrates the increasing deference to the executive on national security matters and highlights troubling legal trends in Hong Kong, including the use of civil law to extend the reach of criminal penalties. Today, our panelists will also explore the broader implications of this case and the judicial challenges posed by political pressures from Beijing. They will also explain how the decision was crafted in such a way as to make it easier for tech companies to comply with its orders, despite obligations to uphold international human rights law. They'll also touch on emerging threats posed by Hong Kong's proposed Protection of Critical Infrastructure bill. It's a cybercrime bill or law designed to impose further restrictions on online expression. So the webinar is going to run for 90 minutes, allowing ample time for questions. Please submit them in the chat and we'll ensure they reach our panelists. Now, it's my great pleasure to introduce our moderator, Doreen Weissenhaus. Doreen is a senior lecturer at Northwestern University's Pritzker School of Law, and she's the associate professor at the Medill School of Journalism, where she leads the Media Law and Policy Initiative. She also taught media law and ethics for 15 years at the University of Hong Kong and is the author of Hong Kong Media Law, a guide for journalists and media professionals. And she co-authored Media Law and Policy in the Internet Age. And with that, I hand things over to Doreen.
Thank you, Holly, for that introduction and for setting the stage for our discussion today. And thank you to Global Freedom of Expression Columbia and its partners, Article 19, and the Georgetown Center for Asian Law for organizing and hosting this very important and timely webinar. We are joined today, as Holly mentioned, by 3 distinguished experts and advocates, who I will introduce in a moment, but I would first like to lay out a bit more a brief roadmap for today's session. Each of our speakers will talk for about 10 to 12 minutes, laying out their observations and analysis of the current crisis of expression in Hong Kong and the implications there, as well as in the region and globally. We will have some back and forth of questions among us, but we will leave plenty of time for our audience around the world to ask your questions by submitting to the chat or presenting on YouTube and other streaming channels for us to ask our speakers. It's my honor to introduce our first speaker, Michael Castor, a human rights advocate and researcher specializing in China and Southeast Asia. He is currently the Asia Digital Program Manager with Article 19, where he oversees projects on internet freedom and digital rights. In 2016, he co-founded Safeguard Defenders, a regional human rights organization with a focus on China, and with whom he continues to serve as senior advisor. Michael has previously worked with civil rights defenders, an international human rights organization that supports human rights defenders who work in some of the world's most repressive regions, and co-founded in 2008 the Chinese Urgent Action Working Group in Beijing, which unfortunately was crippled several years later in a countrywide crackdown on the human rights movement. He continues to consult with many organizations, including Amnesty International, the International Commission of Jurists, and others. He holds degrees in international law and human rights from the Fletcher School of Law and Diplomacy at Tufts University and the University of Utrecht in the Netherlands. Our second speaker will be Eric Yan-Ho Lai, who is a research fellow at Georgetown Center for Asian Law. He's an associate fellow at the Hong Kong Studies Hub at the University of Surrey and a member of the Asian Civil Society Research Network. He obtained his PhD in law at SOAS University in London, and his main research focuses on law and society, law and social movement, national security, judicial politics, and international human rights law, exactly all the topics that we will be focusing on today. Eric is formerly a visiting fellow at the Center for Comparative and Public Law at the university I used to teach at, University of Hong Kong, and is a former visiting researcher at King's College London. Born and raised in Hong Kong, Eric has been involved in civil society development and human rights advocacy since 2010 and brings his unique perspective. And our third speaker, Cheng-Cheng Kwong, is a senior analyst in Interparliamentary Alliance on China, otherwise known as IPAC, as a political and digital rights activist from Hong Kong. She is the founder and former spokesperson of Keyboard Frontline. It's an organization dedicated to monitoring online censorship and digital rights. She was a columnist for Apple Daily, a major pro-democracy newspaper with one of the largest readerships in Hong Kong before being shut down a few years ago. She first became involved in activism more than a decade ago after Hong Kong proposed a copyright amendment bill that would undermine freedom of speech on the internet. And clearly that began a series of new legislative initiatives that continue to this day. She has frequently criticized the Chinese government's use of surveillance technology and artificial intelligence to pursue authoritarian ends. Cheng-Cheng is the Hong Kong campaign's coordinator at IPAC and is pursuing her PhD in law at the University of Hamburg, where she now lives in exile. So I'm going to pose my first question to Michael. Michael, as noted by Holly, there's been a long growing list of restrictions on free expression in Hong Kong since the enactment in 2020 of the new national security law. What is the significance of this particular case involving the protest song Glory to Hong Kong, and what are the broader implications, especially in the global context? And Michael, given your view from Article 19, which monitors free speech around the world, can you help us understand the bigger picture and what's at stake here?
Sure. Thank you so much, Doreen. And also, it's a pleasure to be here with my fellow esteemed panelists. So under international human rights norms, internet intermediaries should be shielded from liability for third-party content. It's sort of a fundamental principle of protecting the freedom of expression and information online. What we see with this case is emblematic of the assault on internet intermediaries. It's going not just at one platform streaming or making available one song. It's part of a larger assault on sort of some of the fundamental principles of internet freedom and how international human rights law is protected online. So in 2016, the UN Special Rapporteur on Freedom of Expression encouraged states not to impose policies that would pressure businesses to unnecessarily or disproportionately interfere with the freedom of expression, later giving us the Manila Principles on Intermediary Liability, which again holds that laws on content restriction concerning intermediaries such as streaming platforms as is the case we're looking at, must be necessary and proportionate, respect due process, transparency, accountability. All of these must be built into any such provisions. So when I'm speaking about internet intermediaries, sort of, what am I talking about? This is about YouTube, earlier draftings of the injunction. Last year, when we first saw the song disappear, we noticed that it was disappearing from Spotify, from Instagram Reels, so from a number of different places. And these are all forms of intermediaries, internet intermediaries. But broadly speaking, there's 4 categories. There's internet service providers or ISPs. There's web hosting platforms like Wix or WordPress. And both of these in particular have also been targeted by the authorities in Hong Kong outside of its borders. Also, we're talking about social media platforms and search engines. And so, there's different models for intermediary liability, from the strict liability model that's imposed in China and in some other more authoritarian states, which seeks to hold intermediaries liable for all third-party content, which is some of the strictest, most censorship, driven models of internet governance. There's the safe harbor model, and there's a broad immunity model, which is in the US under US Code Section 230. International standards tend to favor then this approach. It's been expressed by the independent experts of the Human Rights Council, going back to 2011, the Joint Declaration on Freedom of Expression in the Internet by the 4 global free expression mandate holders and others. And again, back up to then the Manila Principles, which is a really important sort of guiding soft law principle for this. This is meant to guide state practices. And what we see clearly in this decision in Hong Kong and sadly in other parts of the region and indeed the world are states really moving against these types of principles. At the same time, there are responsibilities, corporate responsibilities incumbent upon companies under the UN Guiding Principles on Business and Human Rights and others, in particular tech companies in this situation, to perform human rights due diligence before market entry or for market exit. And again, this is part of the conversation that a lot of people are having in Hong Kong now, as the situation for digital rights, the pressure on tech companies increasingly becomes more authoritarian, more restrictive. What should some of the platforms, what should some of the companies do? Should they exit? Should they stay? And of course, this is a complicated conversation to have, but fundamentally, at least, it must be guided by human rights impact assessments, human rights due diligence, guiding their behavior. But at the same time, the UN Guiding Principles and others call upon tech companies to weigh decisions, weigh their compliance with local orders, local rules in compliance with international human rights law. And so unfortunately, what we're seeing, emblematic of the case here in Hong Kong and again around the region, is a twofold assault on internet freedom brought on by states, taking to increasingly over-regulating the online space with non-human rights compliant laws and policies, and unaccountable tech companies more compelled by market forces, perhaps, than they are by their voluntary commitments under the UN Guiding Principles and others. Powerful countries like China are a driving force of both putting pressure on companies and on platforms, making a very attractive market for them to operate in which they remain for their market access, increasingly compliant with orders and restrictions for data privacy or freedom of expression breaches. And this is the case that's been documented in China for a long time. And again, as a lot of us are alarmed by, increasingly we see sort of emulation of this taking place in Hong Kong. Hong Kong was a once much freer space. And since the imposition of the national security law and others, it has taken on to resemble more closely China. And so this is not hyperbolic then to say how international tech companies respond now to the decreasing digital rights environment in Hong Kong will be a litmus test for how they ultimately react to global phenomenons of rising digital authoritarianism. And certainly as China is increasingly successful through economic, political, through other means to push norm setting through partnerships as part of the Digital Silk Road, or its influence at the international level. We see how China is a leading force in this digital authoritarian embrace of increasing states around the region and the world. And so again, how tech companies operate, how they respond to new orders, new pressures from the state in Hong Kong, again, really will be, I think, an indicator of some of the forces and the challenges that we have to deal with in defending the freedom of expression, access to information, right to privacy, and others online. But of course, none of this stops at the national borders, and not just in terms of international norm setting, but also we see the increasing reliance by authoritarian states on pursuing transnational and transnational digital repression, which again, equally is incumbent upon foreign tech companies to take, a serious look at their corporate human rights responsibilities to protect the human rights of their users, whether from ensuring that their rights to freedom of expression or freedom from surveillance on their platforms are protected. And so, I do fear that, there's a lot more work that we need to do in terms of research, in terms of monitoring what's happening in situations in contexts like Hong Kong, which very much are, I think, emblematic of some of these larger global trends, and how we're able to, through research, through advocacy, work with important stakeholders like the tech community, like the business community more broadly, certainly with government partners, to see how we can better hold back against rising digital authoritarianism. Thank you.
Sorry, I didn't. Sorry. So thank you so much, Michael, for that wonderful brief overview. You packed a lot of information in, but it was all very helpful. I would like to just follow up with 2 points with you, if you could help me elaborate. So obviously, at the dawn of the internet age, it was this idea that this was a global platform and certainly something that would be open to citizens around the world. And China quickly took on this idea of saying that no, that it has to do with national security, that this is a national sovereignty issue, and really pioneered this both on its own, but also in reaching out to other communities and other jurisdictions to follow this lead. And certainly we have seen this around the world. Is there a kind of backlash to this issue where there is now a kind of burgeoning interest on the part of, say, more liberal democracies to be able to fight back against this kind of thing? And then second, where do you see Hong Kong in the kind of wide range of issues that are happening around the world? For example, Elon Musk recently caved into a request by Brazil, for example, and what he was doing with X, formerly known as Twitter. If you can follow up on that, please.
Sure. As you say, I may have packed a lot into my opening comments. You packed a lot into your responding questions, but let me see what I can do. I think this issue of digital sovereignty or cyber sovereignty, as it's, sort of equally or interchangeably referred to, is this approach, this normative approach that China has been pioneering. Russia and sort of other authoritarian state actors have also been wont to push for this sort of normative change. Clearly, I think, hopefully it's clear that look at the actors behind this narrative, this norms change. These are all countries that are single party dictatorships or authoritarian or totalitarian states. So the discourse around digital sovereignty is anathema to the fundamental principles of international human rights law, which calls for universality, right? And to say that that states are allowed then to impose their own restrictions on the cyberspace, regardless of what international standards say, doesn't work by logical extension for the same reason why states are not free to torture just because of some, national, cultural, historical difference. And so, the digital sovereignty arguments are popular with states that seek to find rhetorical escape for their human rights commitments, but they don't sort of stand the test, so to speak. I mean, I think furthermore, we talk about the abuse, the weaponization of national security regulations. The injunction, the initial sort of justifications conversation from the Hong Kong authorities around why this song was, tantamount to secession or sedition. I mean, again, it's spurious to say that a song, a piece of artistic expression, is somehow a threat to the territorial sovereignty, the physical integrity of a state, any more than, lighting a candle in the, privacy of your own home is somehow an act that is, one step short of storming the Capitol or conducting some other physical act of violence. The Johannesburg Principles on National Security and Freedom of Expression and other international principles, really expand on when national security is a permissible justification, a legitimate justification for limiting the right to freedom of expression or others, as are called for in the three-part test. Again, it must be so limited and so confined because it's the popular justification or excuse. And generally, when we talk about limiting these rights in the interest of national security, it's strictly for preserving the physical integrity, territorial integrity of the state, not for the feelings, the emotions of the leaders, and certainly not to protect the sustainability of the ruling party. And that's what we're seeing here, as we see in a lot of other places, unfortunately. And so a lot of these conversations and challenges are sort of interwoven with one another. We see the exploitation of exceptions and really this type of rhetorical jujitsu where states like China or Russia seek to not just to reorient international norms, but to really just make words mean what they do not mean to suit their own authoritarian purposes. And certainly, I mean, there is pushback. And I think, increasingly we see that there is pushback. I think the work, for example, that Chongqing's organization is doing, IPAC and others, is a really important sort of place in which we see coalitions being formed. Coalitions between government stakeholders are important, coalitions between civil society, obviously, the Global Network Initiative. There are platforms where, multi-stakeholder gatherings, people can come together from different stakeholder groups, different sectors. And I think that's really what we need to see happening, because the engineers don't have the human rights expertise always, the researchers don't always have the technical expertise. And when we're dealing with states, they can draw upon a vast array of all the apparatus and institutions of the state. And so we really need to try and counteract the assault on global rights with the same level of systematic, strategic, and sort of coherent thinking, again, based on multi-stakeholderism and sort of the safety and in numbers of coalitions.
Thank you so much. And that gives us a lot to work with. And so this is a natural segue, of course, to Eric. You have co-authored a paper coming out with Georgetown Asia Law Center documenting this injunction, providing an overview of the arc of this saga and what it means in Hong Kong and beyond. So I wonder if you could share some of your findings from you and your colleagues, particularly on how this injunction, what specifically happened in this case, benefits government and tech giants like Google, but at the expense of free speech in Hong Kong and beyond.
Thank you, Doreen, and thank you again, Columbia Law School, for organizing this fascinating webinar for us to understand deeper of how the courts in Hong Kong, the judiciary in Hong Kong, which used to be seen as robust, as impartial and right adherence institutions, and now become part of the attributes of the crackdowns on free speech in Hong Kong. And as Doreen mentioned, my colleague and I, including my colleague Tom Kellogg at Center for Asian Law at Georgetown Law, as well as Lokman Choi, former professor at Chinese University and now a fellow with the Citizen Lab at University of Toronto. We are co-authoring a piece on documenting and analyzing the court rulings of the injunction case on Glory to Hong Kong. So may I share my slides right now here? Yes, I assume you can all see my slides. And as Doreen and Holly mentioned earlier, actually, for those who may not be very familiar with the saga of the injunction on Glory to Hong Kong, the song Glory to Hong Kong was a kind of a protest anthem. Famous and widely circulated and chanted by protesters in 2019 protests. And they were not simply chanting during protests, they chanted it in shopping malls, in schools, and in private housing estate. And at some occasions, like in a football match in 2019, football fans in support for the Hong Kong team also chanted Glory to Hong Kong as part of their solidarity and support for their local football team. And after 2020, when the Chinese authorities imposed the national security law, that song remained popular, not just inside Hong Kong's territory, but was also popular internationally, partly because, unfortunately, some people in some international sports events, this song was unfortunately being misinterpreted as a national anthem of China. And as you can see on this picture, in some international sports events, people mixed up the anthems, using Glory to Hong Kong as a national anthem of Hong Kong rather than the Chinese national anthem, the People's Republic of China's national anthem. So we can say the popularity of the song have embarrassed both the Chinese and Hong Kong governments. But one key question is whether this embarrassment could constitute a national security threat. And in a common sense, of course, it wouldn't, because it's just purely a song, artistic expressions of people's demand for democracy and freedom. But now, the government of Hong Kong considered the circulation of this song was a threat to national security. And eventually, in 2023, they sought the local courts for an injunction order to try to ban the circulation of the song from the internet. And therefore, there were two injunction rulings. In the first place, the Court of First Instance at the High Court of Hong Kong, it made a ruling in July 2023 to reject the government's call for having an injunction against the circulation of Glory to Hong Kong. That was a very rare occasion or a rare result of any cases related to national security during the period of time, because since 2020, the court almost every rulings in favor of the Hong Kong government. And as of now, on criminal convictions on national security cases, there was only two people got acquitted from national security criminal trials. But back to the case of the Court of First Instance, the first injunction decision ruled in July 2023 rejected the Hong Kong government's request, and it rightly found that given the injunction targets only the criminal users of the song Glory to Hong Kong, which in turn would often depend on criminal intent, it is not very clear whether an injunction under civil proceeding would in fact be a useful addition to the existing level of deterrence by using the national security laws or other criminal laws like seditions under the Crimes Ordinance at the time. And the court also rightly addressed that there is a real risk of conflict between using the proposed civil injunction and existing criminal law, including the national security law, because there are lots of new due process elements under the national security law of 2020. And there are also different elements of the existing criminal law which will be different from a proposed civil injunction that could cause a judicial contempt if anyone broke it. If anyone broke the injunction. And there was also concerns whether there would be double jeopardy. So at the end, even the court made a decision that the court should not grant an injunction to the Hong Kong government on banning the circulation of Glory to Hong Kong. The court was also problematic in the sense that it fully disregarded the fundamental rights of free speech and free expressions when they made a ruling. Indeed, it adopted a pro-government view of the 2019 protests and repeatedly signaled its agreement, the court's agreement that the national security law and other laws could be used to prosecute peaceful political speech. And they adopted, and the court adopted a proportionality test that could not, in our opinion, be satisfactory because the proportionality test was not robust at all. And in a ruling of the Court of First Instance, they adopted a conventional Heisen test, which is a conventional proportionality test in Hong Kong's court, to try to argue whether the restrictions on free speech on the ground of safeguarding national security is a legitimate aim, on whether it is acceptable and it has societal benefit. However, in the first place, while the court accepted that there is a legitimate aim in this application for injunction, that is an effective prevention, suppression, and punishment of acts or activities endanger national security. But indeed, one of the problematic concerns of national security laws or national security regime enforcement in Hong Kong was that there is no clear and specific definition of national security. By 2023, when Hong Kong had a national security law imposed by China, the law itself has not clearly defined what does national security mean. And if we compare with international jurisprudence or constitutional jurisprudence, any restrictions on fundamental rights must meet three criteria or three principles: legality, necessity, and proportionality. And when we talk about legality, it's not simply about whether there are written law on the statute, but the law must be specifically defined, narrowly defined, and clear, and to be predictable. But the absence of the concept or definition of national security on Hong Kong's law book made the use of national security just a face value, or it is superficial and being overbroad to be arbitrarily enforced by the authorities. So the proportionality test in the court of first instance was not very satisfactory in a way that there's no review or no challenge on the notion of national security to the large extent. And that said, the court made a ruling to reject the government's request for an injunction, and the government of Hong Kong was not very satisfied. And 9 months after, they sought for appeal of this decision at the court of first instance. And 9 months after, in May 2024, which is 4 months ago, the Court of Appeal in Hong Kong made a second ruling on the injunction case and reversed it, the Court of First Instance decisions. And if I would like to sum up the key takeaways of the Court of Appeal rulings, is that the Court of Appeal ruling distorted some key comparative jurisprudence to approve and issue the injunction that in effect effectively banned the circulation of Glory to Hong Kong on digital space, online for people inside Hong Kong. But the Court of Appeal also repeatedly emphasized the court's duty to safeguard national security and the need for a seemingly heightened form of national security-focused deference. There is a very common notion of judicial deference or national security deference principles in common law courts, as well as other liberal jurisdictions. But this misuse or distorted use of judicial deference was very problematic when we see their reasonings in my next slide. And the Court of Appeal also adopted a very pro-government framing of the 2019 protest. It argued the 2019 protest was a sustained outbreak of massive violence, public lawlessness, disregarding the peaceful elements of the protest, including the chanting of the song itself was a peaceful action of citizens in different occasions during 2019. And of course, the Court of Final Appeal did not revisit and correct the human rights ruling of the Court of First Instance, that they instead reaffirmed the Court of First Instance application of the Heisen test. The proportionality test was appropriate. And when we argue the Hong Kong's Court of Appeal distortedly used the case law or distortedly used the comparative jurisprudence, I will be referring to the fact that if we look at the rulings of the Court of Appeal on that injunction, they cite a lot of UK case law to try to justify that even the United Kingdom's judiciary would agree on judicial deference, which means the judiciary should defer the decisions and judgments of national security matters to the executive government, rather than by the court itself, because the court would have no expertise or no skills or knowledge to determine national security matters. And if you can see on the left-hand side of my slide, the Court of Appeal ruling also cited some UK cases, including the Ryman case, and cited Lord Hopman's speech on his notion of judicial deference. However, if you look at that case in a more in-depth manner, you could find that the reason why Lord Hoffman, as well as other judges, agree with the principle of judicial deference on national security was that, as I highlighted on the right-hand side, such decisions with serious potential results for the community require a legitimacy which can be converted only by entrusting them to persons responsible to the community through a democratic process. If the people are to accept the consequences of such decision, which means deferring decisions to the executive government, they must be made by persons whom the people have elected and whom they can remove. And here we can see when liberal jurisdiction apply judicial deference principles on national security cases, they also refer to democratic accountability. But in the context of Hong Kong, it's completely different. We are not, in Hong Kong, we don't have a liberal democratic institutions, and the electoral systems were reshuffled by Beijing in 2021 from a partial democracy to now a fully authoritarian from a liberal democratic perspective. And if we affirm the use of judicial deference should be tied with democratic accountability, then the Hong Kong Court of Appeals argument would not stand, because they only cherry-picked case law's notions of judicial deference without considering their connections with democratic accountability. Like when the Court of Appeals cited Lord Bingham's statement and case law in the ruling, they also neglected the fact that democratic accountability, a representative legislature, and a democratic government are essential elements to support the application of judicial deference. And as another Canadian judge, Beverly McLaughlin, who was also a former overseas judge in Hong Kong's Court of Final Appeal, she also emphasized the role of the courts in any review of cases if they have to be deferred to the executive authorities. And what we could argue before I end my presentation is that Hong Kong is now a textbook case on abusing national security narratives or national security laws to achieve a political censorship, as is also in alignment with a global study on the impact of counterterrorism laws on civil society and civic space conducted by the United Nations Special Procedures 2 years ago. They received more than 100 inputs from civil society actors from different countries, and to try to understand how counterterrorism and national security laws are impacting the erosion of civic space today. And what they found is really similar as what we have found in the case of Hong Kong, that using national security law to protect the executive and dampening the capacity of social movements and protests to emerge in public space, rather than protecting a genuine territorial integrity or a national defense, safety, or counterterrorism under national security laws. And the judges and local courts tend to be highly differential to the exercise of counterterrorism or security powers, and because judges may also fear retribution if they overrule security prerogatives exercised by the states. And that was also happened in Hong Kong in the past few years, that when local judges try to bring in a positive national security case, say try to grant a bail to Jimmy Lai, or try to permit Jimmy Lai to use an overseas lawyer to defend his national security case, these rulings were either overturned by executive prerogatives. Say the Hong Kong government would seek Beijing's reinterpretation of national security law to override the court decision, or the court itself will try to behave by overturning such rulings. So we can see the national security ecosystem in Hong Kong has made a micro trend of overruling positive national security decision more frequent than before. And such rulings on the injunction case also create a greater legal uncertainties on Hong Kong's business environments, because now tech companies, they would be eager to follow the injunction and follow the court ruling to comply with political censorship. And this will also open a Pandora box, whether when government or the court will request further censorship, expand the scope of censorship, whether international businesses or tech companies would comply unreservedly. And it's also another problem that because of the chilling environment in Hong Kong, local people were not eager to file a final appeal against the injunction at all, especially when the court used some technical reasons to reject an activist request for being a party in the hearing process. That is the activist Chow Han Tong, who is also a human rights lawyer. And as I have shared the global trend of abusing judicial deference, national security, and counterterrorism laws, we can see the Hong Kong government is also following this trend. And this global trend also made a big dilemma for everyone, especially for those who are working in or who are living in liberal democracies, when authoritarian regimes would distort the use of case law from liberal jurisdictions to justify their application of national security imperatives and to justify the political censorship at all. So I guess this is not simply development in Hong Kong, but it's also part of the global trend. And as I said, Hong Kong is now a textbook case. And I sincerely hope that in our following discussions, we will also discuss what would be the opportunities for further intervention or try to correct or improve the existing phenomenon in Hong Kong and worldwide. Thank you.
Thank you so much, Eric, for such a detailed and amazing explanation and analysis of the current situation. We look forward to seeing the paper published. I do want to, it's a wonderful segue to Chongqing, but I do want to make one commentary on what you said, in which you pointed out, particularly your conclusion is one, there's no clear definition of national security in Hong Kong's law, but as Michael pointed out, it is endemic across the world, right? That many countries don't do it. So in this case, it sounds like Hong Kong is even going to extremes where the words of a protest songs, where recently someone was arrested for a slogan on their T-shirt, holding up a phone, with a candle on it for the June 4th vigil and so on, would definitely be a part of that. Eric, I did have one question for you. In light of the fact that Hong Kong has this was famously created in 1997 during the handover of this one country, two-party system, where Hong Kong had its own form of legal system, the common law, which followed UK and other common law countries. And of course, protect the fundamental rights and freedom. Are you suggesting that we're past the point of no return, that Hong Kong, in effect, does not have this one country, two system form of legal protections?
Thank you, Doreen. I would say, in the past few decades, Beijing and people in Hong Kong have two different interpretations of one country, two systems. From Beijing's point of view, as long as Hong Kong remains as an economic city, as long as Hong Kong can use the common law system to help mainland's economy and to stabilize the society, they are happy with this version of one country, two systems. But for most of the people in Hong Kong, one country, two system refers to the enjoyment of basic rights and freedoms, including political rights, say universal suffrage, and free expressions, free associations, free peaceful assembly, safeguarded by the rule of law. And these conflicts of understanding or interpreting one country, two systems is now more or less a issue of a power equilibrium. If Beijing and Hong Kong do not try to limit its power to extend their arms of political control through the national security laws, the local courts would become very difficult to resist such trend, because the courts itself they are not political advocates at all. They are more as a guardians of rights. And if Beijing's and Hong Kong's government's arms become too extensively influencing the society, on the legal system, the court, I would say that sympathetically, the court is difficult to resist such trend.
Okay, thank you so much, Eric, for responding to that. So again, all of this leads up to some very important conversation we have from Chongqing. So when I first came to Hong Kong fairly soon after the handover in 97, one of the things I was really impressed by is that its internet infrastructure was considered one of the freest in Asia. It was just kind of stunning. And of course, when I wrote my book, Hong Kong Media Law, that was a key aspect of that book. Now, of course, there's been a tightening of and threats against this digital space. Can you talk to us more about this ruling, but what it means in terms of the context of technical neutrality and the future challenges for digital rights in Hong Kong and the flow of information, and what impact this has in putting Hong Kongers and online service providers at risk? Thank you.
Hi, thank you very much for having me. It's an honor to be with Michael, Doreen, and Eric on the same panel talking about like digital rights and the injunction in general. So I'm Chongqing from IPAC. So like I'll skip the introduction because I think Eric gives a very, very comprehensive overview of what is the whole context of the injunction. So very, very briefly, I think a lot of you are very familiar with what is like tech neutrality and network neutrality. Is the idea is that law and regulations should not favor or penalize one technology over another, and assumes that technology is designed to be neutral, and that individuals and organizations should be able to choose the technology that meets best their needs. And network neutrality or net neutrality is the principle that internet service providers must treat all internet communications equally, offering users and online content providers consistent transfer rates and a lot of different like things when it comes to access to those information online. So in the context of Hong Kong, from what you have heard from Eric, we already know that the Court of Appeal in Hong Kong has issued an injunction banning the protest song Glory to Hong Kong. And after a back and forth at the Court of First Instance and the Court of Appeal, the government finally succeeded in banning the song, and a lot of the online platforms are being forced to take down those contents. And the ruling is part of a broader restrictions under the national security measures, which threatens Hong Kong digital freedom and tech neutrality in general. So Eric gives a very like comprehensive view of what happened when it comes to the case itself. And the things that are at risk here is like internet service providers and online platforms like Google, YouTube, Spotify. They traditionally do not alter or access the legality of content hosted or shared through their services. They do content moderation for sure. There are certain things that shouldn't be allowed online, like hate speech, like child pornography, all of those things. They do content moderation, but those things are more like in a different category other than political speech that Hong Kongers use to express themselves. And under this context, tech neutrality here and net neutrality here should be understood as to protect platforms from being held liable for user-generated content, as Michael has mentioned in the Manila principle that online service providers should be given an exemption when it comes to liability of what is being posted. And if we look at the judgment itself, it says that the responsibility for assessing national security risks rests with the executive branch, which is the government in Hong Kong case. But if you look closely in the Manila principle, it says very clearly, it is only up to a judicial body, the court, to decide whether or not something should be allowed online. It is never and should never be the decision of an executive branch, especially when this executive branch is not in any way democratic. Like we don't get to elect our own chief executive and so on. And the judgment also stated that the court should follow absolutely what the government has decided to be illegal. So the injunction in this case pressures tech platforms to remove the song from search results and content libraries. And the DOJ has stated that because the song is of criminal intent and therefore they should be removed. But the song is made illegal, not because the court has said this song carries seditious intent by existing. It's being signed by the chief executive, John Lee, in Hong Kong, and says, I'm going to sign an order from the executive branch that states that this song is it's illegal and carries seditious intent, and it's glorifying violence and so on. So there is a clear violation of the Manila Principle of what we would normally understand as attack neutrality and net neutrality. And another issue is that if you consider the judgment that's being then put out, the court considered that a more effective way of interpretation of whether or not this should be allowed is that it would be required for internet service providers to take it down so that it will stop circulation. So it's in contradiction, as Eric said, to the first judgment, which is an injunction is not necessarily the best way to stop circulation. So first of all, we already have a problem when it comes to who decides the content is illegal. And then we have them putting the burden of preventing something from being circulated online, even though the content normally would not be considered illegal in other circumstances. So the impact on ISPs and online service providers is quite clear and easy to understand. That is, first of all, the compliance with removal orders. These platforms, they face a legal pressure to comply with content takedown orders, risking penalties if they fail to act, because failing to act means that they are hosting seditious content, which I'll bring in another case that happened recently to kind of further clarify the burden that they're carrying. And platforms like Google, in this case, and Spotify, they will have to filter out and block access to the song, directly countering their neutrality. That is, they shouldn't be part of the system which determines, it should be the court that has determined that this is illegal, and then they should take it down or notice the user to take down, instead of having the executive branch to say this is illegal and then the judge somehow follow that approach and then say you should take it down. And if you look at the precedent in other jurisdiction in the United States, they clearly state that the intermediary should not be responsible for the content posted, and the same for EU. There should be a separation between content hosting, content creation, so that there is tech neutrality and the principle is being upheld. So I'll now bring in two other cases related to sedition that will also play a role in the OSP and ISP's responsibility when it comes to national security law related charges. So there's a Wong Ho Chan case. So Wong faced charges for sharing a hyperlink to the song that we're talking about, Glory to Hong Kong. And the court ruled that he is illustrating the intention to sedition, and therefore he's found guilty. So treating in this case, the hyperlink itself is being treated as the equivalent of content creation and sharing the content. And that shouldn't be the case. There has been EU cases ruling on this, saying that sharing a hyperlink should not be equivalent to sharing the content itself, because there is a distinction between the link and the content itself. And whoever shares the content should not bear the same responsibility as the content creator. And a more recent judgment came out last month on the Stand News case. The Stand News is an online media in Hong Kong that's being forced to close down in 2021 or 2020, in December 2021, after Apple Daily was being closed down. And their editors-in-chief were being prosecuted with a charge of sedition, saying that hosting certain contents on the news platform counts for sedition. And the recent ruling says that proving recklessness instead of specific intent for sedition is meeting the threshold of sedition. So if you are hosting certain contents that you are not aware of being sedition, for example, before this whole injunction, you thought Glory to Hong Kong is okay to host on your platform, even that you are posting it or hosting it out of recklessness or negligence, you are still meeting the threshold of sedition, meaning that you will be liable for sedition. And this change of the threshold of sedition, because before this Stand News case, to perform sedition, you need a specific intent. That is, you're aiming to overthrow or encourage people to overthrow, inflicting hatred against the government. This change kind of pressures platforms to preemptively censor content to avoid legal risks, undermining the neutral intermediary status. So instead of being ordered by the court in the Glory to Hong Kong injunction, they are now in the active role to look on the internet and say, hey, am I hosting anything problematic, which encourages self-censorship. So if you take all of these three cases into account, you see the pressure and the burden on internet service providers and online service provider is getting bigger and bigger. From Glory to Hong Kong, it is, you have to listen to the executive branch. You have to look out for what you're hosting and take them down. And now it is, if you didn't notice that you're hosting or posting something, you're also liable for sedition. So there's a shift in the platform accountability. The injunction places Hong Kong's international regulations at odds with international standards of platform liability, which is in contrary to the US and the EU, even though there have been voices talking about stricter content moderation when it comes to problematic content, which is definitely not in the category of political speech. And these platforms has to navigate now between adhering to local laws and maintaining commitments to global free speech principles. And how would they balance, should, as Michael said, leave the market, stay in the market? Can they still perform their duties as internet service providers and so on? And as I said, it also create a chilling effect on speech, like because users, they might fear out of negligence or recklessness, they are committing laws. They wouldn't even want to share a link because the link is being seen as the content itself. And also it's encouraging self-censorship on the platforms and the users themselves as well. And now the platforms are being put in a dilemma that they should think about whether or not they want to still uphold their principles when it comes to freedom of speech and internet freedom, or they want to leave. And this injunction and the cases that follow that recently happened sets a precedent for further restriction. And it's a concern for everyone because the internet is not it's all linked. If something is banned, it has an impact on other places as well. And the future of Hong Kong's digital rights, I wanted to be like optimistic when I kind of preparing for the panel, but I just couldn't. It's very grim, to be honest. So I can only see there are more and more like examples of governments trying to silence people, take down contents as long as they feel uncomfortable or they think certain things are inappropriate. And there is not much the users can do under the circumstances in Hong Kong. But there might be space for parliamentarians across the world, tech industry, especially the big platforms, that they might have to think about how they want to navigate these complex legal dynamics because their decisions have a direct impact on the ordinary users that relies on the Hong Kong internet, like whether or not they would uphold like unreasonable requests from the government, like data user requests. Are they answering to those things? Are they going to ban like access to certain information or technology and so on? So a very grim end, but this is all I have for now. And I look forward to talking to everyone about how do we not like be destined to this grim future. Thank you.
Thank you so much, Chung Cheng, for that very sobering conclusion. But I almost hesitate to bring it up, but of course I have to. This is obviously not the end of the threats. It's not a status quo with the introduction of this proposed protection of critical infrastructure bill. What will that do should that be implemented? It's a cybersecurity law designed for further restrictions. What does that entail?
I'd say the proposed like cyber security infrastructure bill will definitely have an even worse impact on the responsibility that online service providers and internet service providers will have to take on. Because first of all, it has a very vague definition of what is included in the scope of the bill, like what kind of online service providers or internet service provider like lies under the critical infrastructure definition. And when the government is being asked, like, what does it actually mean? They come back and say, we're not going to tell you because if we tell you, we exposes them to like a malicious attack, which is not very helpful. So if I am like a small size online platform providing, I don't know, for example, education service, like that sounds quite critical, but probably not as critical as the banking industry. So where do I position myself? And at the same time, that law gives huge power to the government. They can require all information including trade secrets when it comes to your secret recipe to a successful algorithm, for example. You are obliged to share those things with them. And they can also install software as they see fit into your system to ensure that you're secure and safe. And these things clearly oversteps the normal like proportionate and necessary like framework when it comes to thinking about what are the countermeasures to security. And that would put them in a more difficult situation. Like if I stay in the Hong Kong market, I'm obliged to do that. But I don't want to lose the Hong Kong market because at some point it's profitable. And at the other end, the Hong Kong people, they kind of need access to technology. If you take that out of them, if Google leaves Hong Kong, for example, then we're left with Baidu. And that might not be the perfect platform for us to use. And it will have a very damaging effect on Hong Kong as the financial hub, because you need the information to make decisions. And so it puts everybody other than the government in a very difficult situation that we will have to decide for ourselves, like what we want to do. And to what extent are we willing to comply? And I see I was a bit encouraged when I see a lot of like tech companies voice out their concerns, but the government just didn't take them into account when they like in the session, they're like, shrug, heard you, noted with thanks, so we're not going to do anything. So it's even more grim than I just put it in my presentation. But I do think the tech companies do play an important role, and they still haven't put in the effort to try to defend the values that they claim to support.
Okay, I do have a follow-up for that, but I'd like to get to a viewer's question. Adam Bubanik from, hold on, was that from George Washington University? He's at the Sigur Center for Asian Studies. So his question is for any or all of panelists. What precedent does the Hong Kong case and the Glory to Hong Kong case set for digital rights globally, especially in authoritarian or semi-authoritarian states? In other words, does it give fodder for what they might do, which they haven't done? Chongqing, you had mentioned some of the novelty, and Eric as well, about how this kind of changed the liability, this how kind of pushed the ball forward on this. So perhaps we can answer some of this. Eric has a question, but I also would like to ask Chongqing as well. I'm sorry, Eric has an answer to this.
Thank you, Doreen, and thank you, Adam, for your excellent question. If I may put further context of the result of this injunction, is that Google complied it by removing 32 videos from YouTube and imposed what we call a geo-blocking, which means people in Hong Kong will not be able to access to those videos, but people outside of Hong Kong were able to see this video still. And this has two implications. Indeed, from Google's point of view, if I would try to put on their head, they may feel it's an easy compliance because in the first place, it's not a global block. It's a blockade to the access to those videos within the territory of Hong Kong. That was also part of the injunction. And secondly, Google does not have an extensive liability when they only have to comply with the injunction by blocking 32 or 30 plus videos, rather than they have to do active censorship on any future videos or future materials online under their platforms. But this is exactly one of the lessons that we could learn is that now semi-authoritarian regimes and authoritarian regimes can build these virtual firewalls against the local citizens by co-opting with international companies. Before, we can see, like in mainland China, they already have their own apparatus and their own enterprises to control internet access. But now they can collaborate with international or overseas tech giants as long as they can reach a kind of qualified deal or a more restrictive manner of censorship. But here comes to a question is whether freedom of speech, whether free expressions is a fundamental right or not, and whether it could be compromised simply by limiting the scope of restrictions when tech companies like Google, they could defend themselves of using geo-blocking rather than a global block to sponsor their political censorship. And we can see now somehow tech companies, we cannot simply say they are we cannot simply say they are part of the victims, because they have a choice whether to comply or not. They have a choice whether to invest, and they have a choice whether to continue to sponsor this environment. Google is a textbook case as well, because on one hand, they have decided not to engage in the market in mainland China. But on the other hand, we can see in the case of Glory to Hong Kong, they were willing to comply with the court injunction order on political censorship. And this is how we shall be vigilant in the coming future.
I'll quickly add to what Eric has said. I think one of the overspilling effect is it shows that Google actually complies with like these kind of injunctions and laws that hinder freedom of speech. But if you look at Google in Canada, in the US, in the EU, or in democratic states, they take the government to court at the highest level possible. They don't give up. They would appeal until there is a final ultimate verdict that comes out in favor of them or not. Like whatever reason that they're doing it, for profit, for a better internet, for whatever, you can see the very different approach in Hong Kong and in other places. And it reflects to you that they actually have a choice. They can actually take the Hong Kong government to court, but they didn't even try. And like for a random like ordinary citizen, or as Eric mentioned, Chow Hung-tung, who is a human rights lawyer behind bars right now, she might not have the same resources, and she definitely doesn't have the same resources as Google, to be honest. She is behind bars, have limited access to books and cases and so on. But Google, with such a big legal team, still wouldn't take the government to the court, challenging if this injunction is hindering freedom of speech, or trying to get legal clarity and certainty around these like national security law related laws and settings and regulations and so on. So it kind of shows if you have a big enough fist, which is China and Hong Kong government in that case, these big tech companies will comply, and setting a very bad example and precedent, so that other countries is like, oh, that's not too bad. Probably I can try to get Google to take down things that I don't like. And there is also an implication of self-censorship. So the Glory to Hong Kong, if you find on YouTube, you can still find it if you're outside of Hong Kong, because it's geolocation likely blocked, as Eric has said. But if you go on to Spotify, there's nowhere to be found. Not because Spotify took it down. Of course, Spotify will have to take it down in Hong Kong, but because the publishing company of the song, out of fear of the Hong Kong government and all the legal implication that comes with, had decided not to distribute that song to any platform. So you cannot find it on any streaming platforms. And this is kind of encouraging that like content distributor role to kind of shy away from its responsibility to not make any judgment, at least when it comes to these things, to not like make that moral judgment of whether or not it is a good thing to post, instead of just being an intermediary platform and host and distribute content. So I'd say these are the two things that I see that are the implications to other countries in the world and other places in the world.
That's great. Thank you. Michael, I wanted to know if you could address this as well. Yes.
Yeah, please. I mean, there's building on the self-censorship concern perhaps, but also from the tech or from the streaming host perspective. So in June, shortly after the injunction came out, there was another platform that was a global distributor. So in the concern, right after the injunction came out, again, like the owners of the song were looking for another host to stream the song globally, and they turned to a UK-based international streaming media distributor, a very small company based in Scotland called MU Bands. And they were hosting the content for a short period of time, and then it went offline again. A number of people were trying to determine why this was. Article 19, among others, there was an open letter that we were contributing to MU Bands, inquiring, what had happened basically, and reminding them about their obligations under international, their responsibilities, I should say, under international human rights law and otherwise. And essentially what had happened there wasn't an international tech company responding to a extraterritorial request for notice and takedown from Hong Kong authorities. They were acting preemptively. They removed the content for concern of compliance with this vague, overbroad, and repressive injunction. And so what we're also then going to be seeing is, the Googles, the Metas, the X's, of the world. These are massive companies, often with corporate value higher than the GDP of most countries. But then there's the small companies, the smaller, bespoke, intermediaries, hosting services, and others that also have a very critical role within the larger ecosystem, ensuring expression and access to information online. And in the face of potential economic or legal pressure from states like China, we also are likely to see similar preemptive measures to comply with these types of restrictive requirements. In their statement at the time, in fact, MU-Bands oddly enough, chose to say, we're not experts. Unfortunately, that wasn't followed with, but we are interested in what the experts in human rights and the China-Hong Kong space have to say to guide us in how we act. They just said, look, we're not experts, but we're going to do this because, So, I think we're unfortunately going to potentially see more things of this nature as well. And I think just also on your point about how some of these larger companies can behave very differently in different contexts, excuse me. And because this point actually also touches back to the critical information infrastructure and cybersecurity legislation, Apple is really, sort of case in point of this. In 2016, after the tragic San Bernardino shooting, famously, the FBI tried to put pressure on Apple to create a backdoor to the shooter's iPhone. The CEO basically said to do so, would be, is against everything that the company stands for. We would never, act in a breach of our customers, our users' right to privacy. Their corporate human rights charter, corporate human rights policy, again, reaffirms its commitment to, universal principles, user data protection, freedom of expression, all of these things. Cut forward 1 year later, 2017, the cybersecurity law comes into force in China, and China puts pressure on Apple to comply then with localization requirements, data localization requirements in China that forced then Apple to move all of its Apple ID, Chinese Apple ID users' data into data centers that would be built in China. Concerning, but at least Apple would have us believe decryption keys would still be stored in the United States. So we're still adhering to the same user rights that we claimed and fought so hard to uphold when faced with a limited request from the FBI. Now, I'm not taking a stand on the justifications for the FBI's call there, but that was one case. And Apple fought it tooth and nail as much as they could through its legal department in the United States. And then when faced with a far more overbroad order in China to move millions of users' data into China, they complied. And then months later, after the company would have had us believe that the decryption keys would be at least safely stored in the US, they then revealed that, well, the decryption keys for all of this data would actually be stored not just in China, but actually in the same data center where all of this information was stored. And this, not only, as many have argued, is a dereliction of Apple's responsibility to uphold various human rights principles it claims not just voluntarily to have entered into in the UN Guiding Principles, but its own corporate human rights policy. But also, this is emblematic of the types of requirements that this model of cybersecurity governance would impose upon all international actors. And as we see, Hong Kong is emulating this type of cybersecurity governance for now how it's looking to regulate critical information infrastructure and larger sort of cybersecurity issues in Hong Kong, which again raises very serious questions about the future of the private sector writ large, but certainly the future of tech companies' presence in Hong Kong and what that will mean for data privacy and other freedom of expression concerns.
Right. Thank you so much for the really cogent observations, Michael. And of course, this follows up what you've written quite extensively about global tech companies' deafening silence in the deteriorating freedom in Hong Kong. So not just in specific cases about them, but what about kind of this broader voice? What can they do, and maybe any of you can kind of respond to this, to resist this ban, not just on this particular song, but what and how can they move in the future? Is there any leverage that remains to protect free expression in Hong Kong?
Yeah, maybe I can first give a few quick response, and then also looking forward to Michael and Chongqing's comments. If I could follow up with our previous conversation, whether and why Google should file an appeal in Hong Kong to continue to struggle on this case on free expressions, I guess if I were a devil's advocate, I would also see from another perspective. Say, when Chongqing mentioned the cases in Canada and elsewhere, somehow Google were very eager to fight in the courtroom in liberal democracies. But how about in the court in authoritarian or semi-authoritarian regime? You see, in the case of Hong Kong, they were not eager to even engage it or to intervene it. They did not try to be a party in the first place, and they did not want to file a final appeal to the Hong Kong Supreme Court. They call a final appeal at all. So perhaps that also reflect whether they still have faith in Hong Kong's rule of law and judicial independence. When we see the courts in Hong Kong have unreserved deference or affirmation of the executive power on national security matters. So what would be the result for a call of final appeal on this case, or what would be the cost, or is this cost effective, or is it worthy to invest in such a legal battle when we see the courts could not have any way to defend basic rights in face of national security imperatives? So this would be it seems I was present a very pessimistic picture, but I guess it will also need to understand the fact that somehow the Hong Kong government and the Chinese government is facing an economic downturn. And you see recently, even in mainland China, the economic policies is shifting. And in Hong Kong, they are also struggling for improving the economy. So I guess that that would be a kind of opportunity for a greater intervention or greater engagement for stretching the digital space and the space for free speech or free expressions in Hong Kong. But it also depends on the will of tech companies, especially for those tech giants, whether they want to take the lead to be showcases for small and medium firms like the distributors or streaming platforms to see actually there are ways to improve not just on free expressions for progressive political speeches. Free expression is also important for free information flow, for open access, for an open society. These are inevitable for any business person, for any investors to still want to invest in Hong Kong, especially it's not a democratic city.
Right, that really makes sense. So Michael or Chongqing, do you want to follow up with any comment on that, what Eric had to say?
Yes, I think I'll follow on Eric's comment for a bit. I think Eric is right. Like big tech companies don't seem to want to admit that they actually have leverage because of the economic situation. And some of the discussion I heard is, oh, they still kind of want to re-enter or try to enter the Chinese market, or China being such a big country, they don't kind of want to lose the potential of entering that market. But I think it has been quite clear that you kind of have to be siding with the government to be able to develop your business in China. And that is basically against the whole foundation of the internet, that is to connect everybody to have like free flow of information in a very like amazing and very organic way. And that is not going to happen in China. And they will have to kind of face a choice in this. And Hong Kong is a really good test case. Like, what kind of values would you like to forego? Are you willing to like aid authoritarian repression, or are you going to at least try, knowing that it might not be cost effective? But this is a question outside of your business model. It's more like, oh, what does this company believes in? And I think another thing is, I would hope that all the lawmakers in different parts of the world will kind of understand the overspill effect of their own laws when it comes to making laws around tech and tools that we have access to. So there has been a lot of discussion about banning encryption in the US, in the EU, in the UK, everywhere. And it always worries me. It's like it seems to them that they ignore the fact that this has an overspill effect, and it will affect minorities like dissidents that have to be in touch with their family back home, or people who actually need encryption to stay safe. It's of course a good intent to want to like safeguard children, to counter terrorism. Those are like you can't dispute that those are bad intentions, but the way of doing these things always have consequences, and a lot of the times lawmakers don't take what it has on, for example, Chinese dissidents, Hong Kong dissidents into account on what it will do to them. And so I want to like really emphasize like tech neutrality is really an important concept when it comes to thinking about laws. And I see it like slight direction of travel into like, let's ignore that because we need to achieve certain goals. And that's worrying. And I think if that is being taken into account, we might have like better solutions to different problems, and it will help for access of information and technology in Hong Kong as well.
That's great. Michael, did you have anything else to add on that? No. Okay. And so what that raises the issue of whether or not the solution is through a legal avenue. Is it through public relations? Is it getting the information out? Obviously, this webinar, we hope to kind of educate a broader audience about why we should care about Hong Kong. I mean, Hong Kong does not, like in other parts of the world, as part of Asia, does not have a regional human rights court where it can go to if they find that there is something in their own national domestic courts that don't comply with international human rights standards. So I want to throw it to each one of you. What is the one or two things on your wish list that you hope to happen in the near future, whether it's, getting a gathering of tech companies to kind of pull together some kind of common statement of support, or what is it that you see might move this protection, or at least the hope of a little bit more for Hong Kong in the near future? Eric, we'll start with you.
Right. Wishes could be very idealistic, but I hope I could be concrete. Christmas is coming. It's not about like wishes on the Christmas tree, and I would say it's very important. I would sincerely hope all tech companies to rethink of their strategies in Hong Kong. Engagement doesn't mean appeasement. Engagement doesn't mean being passive or being retreat from critical issues. Free expressions is not just about free expressions for activists. Actually, free expression is a commitment or a value for all tech companies when they want to have a vibrant digital space and internet for information circulation and to advance our community. So I guess it's important for them to rethink strategies. And secondly, I would wish Hong Kong's court, after these issues, after these sagas of injunctions, as well as the passage of a local national security law early this March that we conventionally called Article 23, Safeguarding National Security Ordinance. It is right that now Hong Kong has more national security architecture that will further restrict the behaviors of the court in defending human rights or in safeguarding basic rights and freedoms. But I guess the case of injunction also demonstrates the court should have alternative ways of sustaining their common law tradition, not try to be cherry picking on case law from other liberal jurisdiction, but try to be more assertive and positive in making use of human rights cases or human rights jurisprudence to strike a balance between so-called safeguarding national security and defending the fundamental rights of free speech and free expression for the local people. I guess this is a kind of a culture everyone needs to cultivate. It's not just the responsibilities of the court, it's also the responsibilities of the government, of NGOs, of non-state actors like companies and everyone. We need to build this culture together, even though all of us here are not living in Hong Kong, but we are still concerning Hong Kong at best.
Yes, Michael or Chung Ching?
So I am going to make a wish. I hope that every stakeholders in this picture will not see Hong Kong as a place that business is as usual, because it is not. Like, countries have to acknowledge that it is no longer to operate for your businesses in Hong Kong to operate normally. They have to derive business risk advice. They have to give a bit pressure to the big companies and say, hey, probably aiding human rights crackdown is not okay. And I hope that big tech companies, as Eric said, have strategies, think about where they want to position themselves. If they want to aid crackdowns, then they probably shouldn't say we do no evil. And also for users, we have to come to terms with the reality that we have to fend for ourselves, because big tech companies not fending for the users, government is not going to help us in Hong Kong, and foreign countries haven't done enough, in my opinion. So equip yourself with digital security, with access to technology, learn and familiarize yourself with different tools, so that when things happen, at least you are there to fend for yourselves. You know, okay, how do I circumvent DNS tampering, for example, if a website's being blocked? Or how do I change the location of my YouTube service so that I can access Glory to Hong Kong, for example? So I wish everybody like kind of come to terms with reality that business is not as usual in Hong Kong.
Yeah, yeah. And Michael?
Yeah, I mean, in terms of wishful thinking, I suppose. I mean, this December is the 40th anniversary of the signing of the Sino-British Joint Declaration, which also paved the way to the Basic Law and is supposed to be establishing, these human rights and fundamental freedoms that used to, at least in imperfect ways, but at least used to be in place either from the judiciary, the independence of the judiciary, for the protection to freedom of expression, access to information. The reason why, when China was developing its Great Firewall and creating the epitome of an intranet, a government-run intranet, Hong Kong was still a free, open internet space, and it's been so under assault, and that from that we return to those principles. If we're wishing, I mean, that the one country, two systems model that you mentioned would be returned through pressure from stakeholders. And one, of course, I think is, to remember that within the Basic Law, within these documents, that Hong Kong, not the mainland People's Republic of China, but Hong Kong is a states party to the International Covenant on Civil and Political Rights. And for that reason, it does have periodic review by the Human Rights Committee. And in 2022, in its concluding observations, when the Human Rights Committee did review Hong Kong, among its concluding observations, specifically on the national security law, again, was that it failed to adhere to international principles, it failed to adhere to Hong Kong's obligations under the ICCPR, and the Human Rights Committee called upon Hong Kong to repeal the NSL, and in the meantime, to not implement it. And if we then extend that out to remind, tech companies or others who would then act upon orders from the authorities, as Eric mentioned earlier, this came from not an independent judiciary, and Chung mentioned not judicial review, but a certificate issued by the chief executive acting on powers granted to them under Article 47 of the National Security Law. And so anything coming out of it is then something that the Human Rights Committee has called for repeal, non-implementation, and that might get us back to then some of the imperfect, but certainly better than where we are now, one country, two systems.
I want to make clear that I wasn't just asking for gifts under the Christmas tree and, frivolous wishful thinking, but using all of your many years of expertise, both within the region and outside. What are some of the positive steps forward? And things like having what Eric suggested, having tech companies acknowledge that engagement does not mean appeasement, where Chung Ching says that we have to fend for ourselves. We have to come to terms with the reality. What can I do to protect myself and my access for free expression? And then again, of course, Michael, recognizing there is a purpose for recognizing these major anniversaries, because it reminds us and puts it back in front of us of what were some of the fundamental issues that we were fighting for at the time that these came into fruition. So I see that we're out of time. Let me just see what's in the chat here. Yeah, so I do want to thank our speakers for your incredibly valuable insights and analyses to help us further understand what's at stake in Hong Kong and for its people and the digital space and what it means for the world at large. I want to thank again Global Freedom of Expression Colombia and Article 19, which seeks to strengthen freedom of expression worldwide. And that's by advancing the understanding of both international and national norms that best protect this flow of information, expression in this interconnected global community. And of course, the Georgetown Center for Asian Law for its unique academic contributions on cutting edge topics related to Asian law and policy. And most important, we want to thank you, our viewers, who joined us this morning at various times during your day, some of you in the middle of the night. And we hope we can all continue to engage on these critical issues facing Hong Kong and beyond. And I pass the baton back to Holly.
Thank you, Doreen, for that expert moderation. It was an incredible discussion, I think, and wildly informative, fascinating, but also somewhat depressing. It is a critical global issue, and I really hope that this will galvanize some sort of momentum to take more forceful action on these issues. So thank you, everybody, and thank you to the audience. I do want to let everybody who's watching know that we have a lot of resources posted on the Global Freedom of Expression website. All of our speakers sent us really great articles and papers and background material, so please go there and find more information. And as soon as Eric's paper's out, we will definitely announce that in our newsletter. So keep an eye out for that. And we are also hosting next week, for anybody who's interested, a panel on humor in the law. So you can register online for that. So again, thank you everybody for this discussion, and we look forward to seeing you soon. Bye-bye.